Okay, good morning. Welcome back. My 6-month-old got up at 4:15 this morning and didn't want to go back to bed, so I am kind of here, sort of. Great. So there may be a storm tomorrow. There may not be. Just for those of you who have wondered why I didn't schedule makeup days, it's because we had 3 or so extra days because an academic hour is 50 minutes and you're here for actually more than 3 times 50 minutes, right? Because this is an hour and 20 minutes times 3 is 4 actual hours. So we had some days in the bank. They are now gone. So we'll see. We'll see if I'll send you a note tonight if we're not going to be here tomorrow. We'll see what happens. We'll see how fast we get through the material. If we need to schedule a makeup class. I hope not. All right. So what's our action plan? First of all, welcome back. Welcome. Those who are coming in, welcome. The plan for the next 5 or 6 weeks is this week we're going to wrap up the 33 Act. We'll do the practice exam together here in just a minute. I hope everyone's taken a look at it. And we'll talk about underwriter liability. We'll wrap up some loose ends. We're not going to go through every, it's just too much material, too much information to go through every single nook and cranny of the 33 Act, what remains on the syllabus. So I'll just highlight a few points probably on Thursday, it looks like. And then we're going to start next week insider trading. You'll notice that on the syllabus, let's see if I can get the syllabus here. You will notice that the insider trading material has less casebook reading and more cases. You should really read those cases. I'm also going to supplement the list of cases in section 3 of the syllabus with, I'll upload this economics of insider trading, but also I will supplement with basic and matrix, which are 2 cases concerning materiality that we did not discuss when we talked about Texas Gulf, but that are more interesting in light of insider trading liability. Sorry. They were in the readings, but we didn't discuss them. So I'm going to ask you to reread them, or at least come prepared. So the cases on the syllabus in 3B2, like Chiarella, and for example, Chiarella, Salmon, and where is Dirks? Dirks is probably in the casebook reading. Anyway, those are some key insider trading. I'll put this all in an email, don't worry. But there are some key insider trading cases that you need to know. So read those carefully. We will sort of have a Texas Gulf style conversation. There's really not a lot of other casebook reading for this section. So we'll spend a couple more weeks on insider trading, and then we will move to fraud on the market, which is section 10B, and we will wrap up with fraud on the market. So that's the plan. So this is the end of the 33 Act, the beginning of the 34 Act, and really the most interesting part of securities law, I think, is saved for the end. The practice exam hypothetical, which we'll talk now about, just to say, could really serve also as an insider trading question. But actually, the whole conversation we're going to have today is going to have nothing to do with insider trading liability. So you can now go back to this practice question after we finish the insider trading material and think again about whether there might be additional liability under insider trading law. But let's just sort of recap the practice question. We have a company, Metallica. Metallica is a steel manufacturer based in Lexington, and it's been wholly owned by Iron. Iron is the founder and CEO of Metallica, who has decided that on February 1st, he's decided that the time has come to sell some of his shares. And so Mr. Ron asks America First LLP, a local law firm, to prepare the Form S-1 filing. The next day, prior to filing the Form S-1, Mr. Ron receives a phone call from a longtime friend who we're just going to refer to as the therapist. The therapist is presently serving in the White House in an advisory role whose precise responsibilities are unclear, but generally involve unscheduled periodic discussions with the president concerning matters of great national importance. During the call, the therapist told Mr. Ron that, as was well known and reported in the financial press, the president had been planning on imposing a tariff on steel imports, which would benefit manufacturers like Metallica, steel manufacturers like Metallica. However, just 30 minutes prior to their call, the head of the National Association of Steel Manufacturers, of which Metallica is a member, tweeted from her personal account that Alec Baldwin did a great job on SNL last night. Approximately 45 seconds after the tweet was posted, the president stormed into the therapist's office shouting, "The steel industry will pay for this." The therapist admitted that it was unclear whether the steel tariff would be enacted in the end, but it seemed doubtful as the therapist had never seen the president quite so angry before. Mr. Ron mentions this call to his lawyer, who promptly instructs Mr. Ron not to worry about it, remarking that it's better for investors to believe that Trump will impose the tariff. You will get a higher price in the IPO. The lawyer then promptly called the underwriters for the deal, Blockchain Utopia, LLP, and mentioned there might be a question around steel tariffs that you should look into. I think it's nothing, but give your friends in DC a call. Blockchain Utopia did nothing further with that information. On February 10th, Mr. Ron spoke at the book club of West Palm Beach, Florida, to a group of new retirees, saying, "This is the time to invest in steel manufacturers like Metallica. Just look at how much money the early adopters of Bitcoin made. If you want to truly enjoy West Palm Beach and retire Florida style, you too should get out there and buy Metallica stock when we go public." All right, on February 15th, they filed the S-1, omitting any mention of doubt concerning steel tariffs, but noting that the political and public policy landscape has never been more favorable to steel manufacturers, both in terms of legislative as well as possible executive action. Analysts jumped on this language, remarking on CNBC that this is further confirmation that steel tariffs are on the way. The price of other publicly traded steel manufacturers rose following the following the S-1 filing. On February 16th, the SEC declares the registration statement effective. Trading begins. The Metallica stock price skyrockets in anticipation of the coming tariff announcement. After several days, to everyone's disappointment, rumors begin to emerge. There's no tariff. Rumors begin to emerge that economists had successfully convinced the president that tariffs did more harm than good. On February 20th, the stock prices of steel companies begin to decline, and Metallica stock falls by more than 30%. Investors realized Metallica was not such a great investment without these steel tariffs in place. 5 days later, Mr. Ron and the therapist are having lunch. The therapist tells Mr. Ron that the president's mood about the steel industry had been shifting recently, primarily because the National Association of Steel Manufacturers recently installed a life-size statue, that should be statute as in statute, of the president in its lobby. Noting that the price of Metallica stock was extremely low, Mr. Ron began to purchase large quantities, which caused the price to rise, even higher than it was on February 20th. On March 1, the White House announced new steel tariffs would be imposed. The price of other steel manufacturers jumped tremendously after the announcement, but Metallica's price remained unchanged. Okay, so there's two questions. So just to give you a sense for how you should prepare over the next few weeks, remember I said you can bring in 5 pages of double-sided notes. So you'll see from this kind of a question, I'm really not testing you on the sort of rote memorization or nuances of this stuff. I think you can look it up. I think you can look it up in practice, and you can look it up in now, and it's not interesting. What is interesting is to see if you understand the material, really understand the material, And so, so my recommendation on a question like this, which you'll probably have two of them, is to first try to find the big picture idea. Okay? So it's always helpful, I think, to organize your answer. Start out with showing that you really understand what the question is trying to get at. Now, maybe you don't. That's okay. I'm going to try to help you see that. But this is first and foremost, again, about your sort of analytical capabilities, right? So what is this question really about? Let me turn it now back to you. There's a lot of pressure now that I said that. But can someone try to give me sort of the bottom line? What is this question trying to get at? What's like the real sort of issue in this question at a kind of a very, bless you, at a very fundamental level? What is this question trying to get at? Anyone want to be so brave? Yes, Mariah. So those are good. Those are all issues that need to be spotted. Good, but we're in those. That's all right. That's correct. But I want you to think even more like before you get to the law, before you get to, these are the legal questions. These are the issues, and I'm going to analyze them. Just sort of taking a step back and thinking about the story. By the way, for those of you who don't know, this is sort of based on a true story. Okay, if you for those who follow the news. Just Google, or if you don't, just Google Carl Icahn and steel tariffs. So Carl Icahn traded on steel tariffs announcement, the steel tariff announcement before it happened. I'm really not that creative. 2 kids, it's just, so just read the news and, probably the question will be there in some form or another. So what is this question really getting at before we get there? Okay, before we get to whether there's an offer. Materiality is going to be the big issue, you're right. But just at a story level, what is the story in this question? Yes? Right, but that's still operational. So the hypo. Let me kind of get you in the right direction here. So the hypo is designed to pose a puzzle, a challenge for you. Are pending public policy changes the kind of information that we want securities law to be disclosing or regulating? Okay, this is a question about pending public policy. Okay, so I want you to start there, right? So all this is correct. These are not incorrect answers. They should be part of a good answer. But try to see the forest before the trees. Right? The trees before the forest? Whatever. Okay? Try to see the big painting before you sort of zoom in and understand what the picture's about. This question is designed to, and really when it should be like the theme you kind of hit in different ways over and over again if you really want to write a great answer, which is is this the kind of information that securities law should be disclosing? That's the sort of core around which you want to build a correct answer, right? But that's the idea. And yes, materiality, and Mariah's right, materiality is going to be a big element in this analysis, right? Because a lot of whether or not this information should be disclosed is going to turn on materiality. But before we get there, just recognize that it's not at all clear at first glance that pending public policy legislative changes that could impact a company are the kind of information we want securities law to be dealing with. That is a very difficult question. Very difficult. And one of the first things, so we want to try to develop an intuition in the sense for what is this question trying to probe? What is this question trying to get at? I would be impressed if I read an answer that started with something like, look, this question really highlights a very difficult puzzle, which is, are pending changes in the law the kinds of thing that securities regulations should be disclosing or should be requiring to be disclosed? Okay, so So as far as walking through, like how would you write this answer? So I would try to start with something that shows you really see the essence of the question. And then as far as sort of organizing your actual answer, okay, so start with A and B, because please answer the following two questions. So start with A. Okay, so A asks for these two shareholders, right? The group that bought, basically think of this as like overpayment and underpayment, right? So the group that bought at a price that was too high, and the group that sold at a price that was too low are unhappy. All right? So they are going to want to bring suit. Now, the first sort of legal, formal question, now sort of getting into the answer, is what basis is there for bringing suit? So start formally, like you would as a lawyer, okay, with a section of the 1933 Act that allows you to bring a lawsuit. What would that be? There's actually a couple here. What's one? 11, exactly. My going is right, 11. So first part of the answer, right, a good answer is like, look, for these shareholders, they need a basis to sue. Section 11 provides that basis. I'm not going to do the entire answer here. I'm just going to walk you through the key elements, right, and sort of what you need to be. You can apply the law, but let's tease this out. So Section 11, provides for liability for an untrue statement or a misleading omission, and then you want to try and find in the facts something that could be the basis of a misstatement or omission. What is a good candidate in the facts that could serve as a Section 11 violation? Is there like a quote? Yeah. Great. Exactly that there could be legislative or executive action. The political and public policy landscape has never been more favorable, both in terms of legislative as well as possible executive action. Okay, I'm going to go a little bit faster here just for time, but just to some of the key points, right? So is that a misstatement? Is that an untrue statement about a present fact? Well, maybe, right? You all read Getting to Maybe, so maybe is always the answer, right? Like on the one hand, there is kind of a fact implied there, right? That it's never been more favorable seems to be a statement about the present, right? So that would be something to bring out. On the other hand, I don't know, what fact is sort of there? Is that an opinion? Is that like a sort of omnicare like I believe? Okay, so, the words I believe aren't there, but maybe we should read into that opinion. What fact exactly is incorrect? How could you show that the landscape hasn't been favorable? Is this a forward-looking statement? Probably, because of the reference to possible legislative and executive action. So we know to apply the safe harbor for forward-looking statements. Is there an omission here? Maybe it's a misleading, in addition to the statement potentially being misleading, because let's just back up a second. So is the statement misleading, okay, is a difficult question, not only because it's not clear that there's a statement, but it's also not clear that there is a fact that puts that statement, that makes that statement untrue. Okay, so President Trump's intent to, change, like his momentary anger at the SNL tweet may not, forget about materiality, like just try to keep these separate. It may not rise to the level of calling into doubt whether or not legislative, there could be favorable legislative or executive action. One argument for that is you might say, look, Trump doesn't really set the policy agenda anyway. He's kind of at the mercy of John Kelly or whatever. Like, in other words, so, it's not clear that there's actually a misstatement. But even if there were a true statement, okay, so even if there were no misstatement, there could still be a misleading omission, and that the Trump, what the Trump said to the therapist, Trump sort of changed intent, may be the kind of fact that is necessary to make an otherwise true statement not misleading. Does everyone see that? Okay, so this is how you get points, right? Which is to be very comprehensive and thorough and careful. If this is a forward-looking statement, there might be a duty to update or correct, duty to correct, not a duty to update. Of course, the question is, that isn't actually a Section 11 issue, right? Because the duty to correct comes up later, so it would have to be some other basis, so we could come back to that. But shareholders are asking for all bases on which they can sue, so you might as well talk about 10b in that setting. And the question, is this like the ink that's smudged? Remember on the fax machine example? Was this like 10,000 that's read as 100,000? Or is this like some fact about the world that investors should have expected could change? So remember, and this is where you really, I think, elevate from sort of B+ to A-, is to say, the scope of what investors' expectations are, okay, what investors reasonably expect is really kind of a normative question in this setting, right? So do you have an expectation that, Trump might change his mind? That is, in fact, the question, right? The really interesting question is whether you have that expectation as an investor. Because if you do, then there's no duty to correct anything. Because that was your expectation. Your expectation was that the world would change, and when the world changed, that was consistent with your assumption or your expectation ex ante. Thus, there's no duty to change anything. Does everyone see this? We talked about this. I just want to make sure you see it in an applied example. So if I think that Trump is fundamentally unstable, is going to change his mind, every investor knows that, you could argue, then in fact there's no duty to correct anything. There's nothing that about the world that has changed. Yes?
On that point, is it what would every investor have to think that, or is it more about what a reasonable investor would think?
Well, so none of this is actually empirical in its claim. Like none of this is actually true. Like, you couldn't bring the court survey evidence of what investors believe and try to convince a judge that investors believe that Trump might change his mind. Okay? So it's all an ex post judicial reconstruction of what investors should think, right? That decision, is supposed to basically align the duty to disclose with broader public policy goals. It's the way to think about this. In other words, if you're a judge and you feel that investors should not be, normatively, should not be assuming that Trump will change his mind, then in fact you want to find that there is a duty to update, and whether or not you think investors should normatively have that expectation depends on whether or not having that expectation is a good idea. In other words, it depends on whether or not disclosure in this setting of changing public policy is a good idea, or changing public policy intent, right? So, in other words, the answer to this question of what investors think or don't think is actually just a sort of entry point into the real question behind this question, right? Which is, should securities law become a vehicle to put President Trump's private conversations on loudspeaker? That's getting you closer to a really good answer, because once you see that the duty to update and the duty to correct are just, like in this setting, finding that there is a duty to update, for example, just one example, finding that there is a duty to update, or a duty to correct, that is, finding that there's a mistaken fact here. In other words, there must be subsequent disclosure. Once you see that that is just a way to get President Trump's private conversations on loudspeaker, then you've now sort of changed the question, right? The question, correctly defined, is whether, like in Texas Gulf, we want this private information being pushed out into the world. Okay, and that comes back to our tension between informed trading and disclosure. Now, in this part of the question, you don't need to go into all that, because I gave you a part B to do policy, right? But you want to show that you understand that, right? You want to show that it's totally arbitrary. It's kind of like, I'm just going to decide whether or not investors could have expected a change in Trump's mind. Does everyone see this? Yes, Magdalene. Right. Yes. Yes, to not have misleading omissions. Right, right. Yes. 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 Yep. Yes. Great. Absolutely. Great. Yep. That's right. That's right. That's right. Magdalena is pointing out that you can get to a lot of these questions without even having to go to the duty to update or correct. You can just say that sort of contemporaneous information about Trump's opinion is in fact rendering the existing favorable legislative and executive. So if that wasn't, I went very quickly over that, but that should absolutely be in your answer, right? So there's a contemporaneous misleading concern. There's a contemporaneous fact that hasn't been disclosed to the market, namely that Trump is, furious with the steel industry, right? Now, you could push back on that and say, well, the tweet was public, right? So, that's why this is a tough question, okay? And just so you understand the way I like to give tests and think about the law is like, this is what's really interesting, okay? It's not like the fifth exception to Rule 215, and come on, you can look this stuff up. But really thinking about whether Trump's reaction to a public tweet is the kind of thing that can give rise to millions of dollars in securities liability. Okay? That is a very, very relevant question. Very relevant. It can happen all the time, right? And one pushback here, in addition to the fact that the guy's probably very unstable in his policy reactions, he can be angry and then the next day not do anything about it. That's one problem. The other problem is that it's not clear that there's anything non-public here. That is, it's not clear that we need disclosure or we need an affirmative duty. In fact, it might be injecting more uncertainty into the market to have the firm announce all the time or put in its S1 or release press releases about private conversations that it's heard about folks having with Trump. I mean, it's kind of crazy that you might think that should go on loudspeaker because after all, everyone saw the tweet and everyone could infer that it was from the National Association of Steel Manufacturers and thus Trump might be a little unhappy. And if he's unhappy, that sort of increases the probability that he's going to change his mind on the tariffs, right? So a good answer, right, good lawyering here, it shows that you really sort of see the arguments and can articulate those applied answers, right? So just giving something generic about the importance of prices being accurate is not as good as saying, let me tell you why, in this case, we might already have accurate prices, It's Twitter at the end of the day, right? It's public information, etc. Okay. Any more questions on this part of the analysis? Okay, let's go to materiality, right? So this is correct. It's correct to say this is the duty. Okay. It's correct to say that this is about a duty to disclose. We're first trying to find some basis under which we can nail you for not having said something or saying something misleading. We then need to show that materiality is satisfied. Okay, materiality, we know from Texas Gulf, is a probability magnitude test. This is probably the most points on this part of the question because it's really the issue. I was talking to Merritt Fox about this exact issue, and we both agreed that, the question is, if this were coming from, the Secretary of Commerce or whatever, that would be one thing. But it's coming from a guy who literally just says things, and who knows what they mean, right? Maybe they mean something, maybe they don't. So there, of course, you should see that I'm just begging you to talk about probability and magnitude, because the probability could be quite low. Magnitude might be quite high, but the probability might be quite low. You might talk about the relationship between Trump and the therapist. Does that increase the reliability? If this were a stranger, would that be different? A stranger overhearing You could spin that both ways. You could say that Trump likes to sort of say things to his confidence that is often contradictory. On the other hand, this is the therapist after all. Okay, so these are points that you'd want to bring out. Of course, Texas Gulf, like we discussed, kind of leaves us hanging on whether or not we can always kind of find an answer in either way to the probability and magnitude test. I don't know. Does this cross the threshold? Beats me, right? So think again about the choice between informed trading and disclosure. Try to show that you understand that. Here, one way to frame that is if we find that this kind of information is material, such that disclosure is required, then in fact we have to think who we'd be taking money away from and who would we be giving it to. So we might kind of taking money away possibly from Mr. Ron or possibly from the therapist. So you'd want to think about that. You'd want to think who, if there was an announcement about Trump's private conversations, that would possibly reduce uncertainty around the price, reduce bid-ask spreads, increase liquidity. But it might mean that the therapist goes out of business, right? That the therapist may be sort of able to sustain his or her operations by virtue of these trading profits. So think about, we talked about cancer abstracts, how maybe we want to subsidize costly investments in biotech research. So think about those settings. Think about Kylie Jenner in Snap. Think about there was something else that happened with Snap this week. One of you emailed me on. Yeah, Rihanna. Right. Think about Rihanna. Right. So think about how we maybe want certain key actors to be able to pocket the profits from forcing information out there because otherwise they won't care, maybe. In some settings that's more compelling than others. Does the therapist need to trade on Trump's anger in order that Trump's anger would make its way into market prices? That's the question, okay? Keep that in mind. That's the question. All right. Any questions on substantive Section 11 liability? I'm going to go a little bit faster here, so we're going to spend the whole class on this, but just so you see, it's a lot to do in an hour and a half. All right. Metallica, Mr. Ron are strictly liable. So you want to talk about who, because the question asks who can be sued. We know that under Section 11 there's strict liability for the issuer and pretty much for an insider. Mr. Ron is selling his own shares in the offering. He's clearly strictly liable. What about Blockchain Utopia? Okay, can they claim a due diligence defense? So this is kind of contorted, but it's kind of fun, right? So what are you supposed to do as an underwriter? How are you supposed to conduct due diligence into the possibility that steel tariffs will be imposed? So, and why I thought this question was fun is in the typical securities law setting, you're talking about are the manufacturing plants functioning? So let's conduct due diligence. Let's look at their customer and supplier agreements. But policy, how do you so give your friends in DC a call. Is that a red flag? WorldCom. So, there's a red flag here that there might be a policy change. So this is sort of harder to sustain, but I don't know. If I'm an investor and I were to have found out that the underwriters knew that there could be a policy change that makes this company worthless, wouldn't I be mad at them? So bear in mind, when we talked about WorldCom, that underwriters like to try and say, no, there's no way, that's unreasonable. But courts are not kind. Look, they don't look kindly on that. The idea that you can just sort of walk away with a high price after having basically, profited at the expense of the buyers is not something that's going to sit well with the courts, and they might really try to read into that statement, give your friends in DC a call, a red flag. Anything else on Section 11? Any other questions or comments, things that you caught that I missed? No? Okay. So you see how to do this, right? It's really not that much law. It's really more about your thinking. Okay. Section 12. Violation of Section 5. When might that have happened? Someone tell me, when could there have been a Section 5 violation? Where? In Florida. Come on, we read Arvida, right? It's always going to be in Florida. Come on, you didn't think this was funny? Okay. No, we did not think it was funny. Okay. It's too stressful. All right. This is the time to invest in steel manufacturers. Is that an offer to sell? Well, I don't know. Maybe. Okay. So you want to apply Arvida and what we learned there. Maybe mention Chris Kraft, but notice it's a little similar to Arvida in that you're kind of telling these retirees in Florida about. But you know, there are a lot of differences, right? We don't really have the concrete sort of description of the business here. We also, there's a key qualifier in his statement, buy the stock when we go public. All right, does that turn it into to take it out of being an offer to sell? Probably, again, in actual practice, there would be case law that you would point to on something like this. But I'm, in this setting, more interested in you kind of thinking about this a little bit more abstractly. Think about whether or not, you know, remember think about the rationale behind Section 5 is to have this period of time where there's a quiet sort of no talking in the market. Why is that? Because we said that we don't want investors kind of swept up because they might be too quick to buy at an inflated price, and that overpayment, underpayment risk is what we're trying to minimize. Maybe, remember, that's sort of in and of itself tricky. But if we are, then you might ask, is that actually happening here? Because here, you, in fact, can't buy that moment. So if you get all excited thinking you're going to get the next Bitcoin, in fact, you can't go and buy. So it's different from Arvida. There isn't actually a solicitation of money at this moment. Maybe. Okay. Any more on section? Yes. Oh, good. So Manuela says maybe this is there's no Section 5 violation because it's not using the mails or instrumentality. Well, it's true. You could. This is in Florida, but this is a Kentucky company, and so I think. I mean, it's worth mentioning, but I don't think you're going to get a This is sort of a quasi-constitutional limitation. I think it would be hard to say Section 5 doesn't apply because this is a purely intrastate offer. I mean, the fact that he's sort of coming from Kentucky and speaking at this event in Florida probably is enough for those who haven't taken con law, the instrumentalities of interstate commerce is interpreted, construed very broadly. There's tremendous federal power. In con law at Columbia, you do federalism, right? Not First Amendment, right? So, like, you should know all about this, right? Okay. So, you know, it's very broad, very broad. So it would be hard to say Section 5 didn't apply for that reason. If it were a Florida company sort of selling to Florida, you know, in the neighborhood, but that's very, very unusual and unlikely. Okay, anything else on Section 12, Section 5? All right, again, keep in mind the 10b question. All right, let's talk a few minutes about policy. So I'm giving you an opportunity in Part B to think about policy implications of public policy disclosure. I happen to think this is a really interesting and important question, particularly as public policy, pending public policy changes can in fact have very important, effects on public company valuations. We saw this with the tax cut, for example. We see this with the steel tariffs. What I really wanted you to see in this question, besides sort of the generic, again, there's no reason, don't waste time giving me a generic summary of what we discussed in class about overpayment and underpayment and investor protection, and it's got to be linked to consumption, and it's got to make investors better. Just save the ink, right? Save the time, and apply the idea to the question, all right? So the first thing I would talk about here is that the question is there what is the nature of overpayment risk for macroeconomic policy, all right? So as I said in the beginning, this question is all about the disclosure of pending policy changes. Another way to say that is, am I overpaying for a company because of a policy change that could make that company less valuable than it presently is. And one issue with this question is that policy changes often affect entire industries or multiple firms at once. And that's a very important fact, because if you remember our conversation around sort of idiosyncratic risk was that it's like a coin toss, and so you're just as likely to have a good day as a bad day. That doesn't seem to work as cleanly in this setting. And for those of you who were curious about policy changes that can kind of be linked to consumption, that are not canceling out, that are not idiosyncratic, here's a good one. Okay? Yeah. Exactly. Mm-hmm. Yes. In fact, Magdalena's point on cyclicality is excellent, and I would go even further to say you can say a lot about cyclicality in this question. So, for example, you can say, look, the ability to pass public policy is itself cyclical. Okay? So my ability to change tax or tariff policy is tied to the state of the economy. When the economy is doing well, I'm more likely, as a political economy matter, to convince lawmakers to take risks like enacting a tariff. Well, okay, you didn't need lawmakers to enact a tariff, but tax cuts, or just to convince, he doesn't need Congress to sign off, but he's obviously making this decision on the backdrop of a complicated checks and balances politically, and that constrains what he's able to do. So, the economy's doing really well. People are kind of more willing to let him experiment, you might argue, with tariffs. That is like a story that is inherently tied to the cyclicality of the economy. So if the economy is doing really well and we can pass tariffs as a result, then the effect of overpayment for these companies is likely to be very pro-cyclical, right? Because I buy essentially the company, or the risk you're concerned here is that the promised policy change will not come to pass. So suppose you buy thinking that it's a good time, thinking that there's going to be a policy change that's favorable for your portfolio. You buy these firms, and then it turns out that there's an undisclosed fact that the policy change is not going to happen. So that just destroys value because you don't get the benefits of the tariffs. But it could very well be that that information on average tends to be revealed sort of as the economy is crashing. I mean, one slight twist to this story is to just say, instead of it being a Twitter inspired rage fit that led to the policy change being contemplated, it could be that there was bad economic news, right? And that bad economic news, in fact, makes these investors who purchased in what are effectively good times on the basis of this pending policy change then find out that they overpaid because the economy is going downhill that the policy change doesn't come about. Okay? And when that policy change doesn't come about, the value of their shares craters. Okay? So policy changes are a great setting to think about cyclicality and consumption and why we might be worried about investor protection here. On the other hand, you could say, look, in this setting it was Twitter, and so maybe it's not as compelling because Trump can change his mind in any direction at any moment, and that's much more like a coin flip. All right, so good answer to part B does this exercise that I just articulated. That's what you want to be writing, all right, in your answer. What else? Think a little bit about who should get the profit if there isn't disclosure. Maybe investors lose in this story. They lose when times tend to be worse on average, but in fact, it turns out that the beneficiary of that is some group of individuals who provide a socially valuable service. So it could be here. It's hard to think that the K Street lobbyists that might have inside information on policy changes need to be subsidized. But there are arguments. Imagine, let me give you an example. Imagine, an organization that lobbies for education policy, like let's think of a more benign case. You know, we have an organization that lobbies for lower income families to have better education options, and they can barely make ends meet. And it turns out that their sort of advanced knowledge of a policy change would allow them to keep the lights on. Okay, so you can see how you can tee up a setting where it's not so nefarious and it's not so smoke-filled room-like, but rather there might be a strong social case for allowing the informed trading, and even if that leads to losses that are cyclical in nature for investors. Okay, does everyone see how to answer this? Nobody will be surprised. I'll maybe do one Q&A review session at the end of April, like the last class maybe, or something like that. But I'm not going to do this again. So ask now or come to office hours if anything is unclear. And you can use this same hypo to study insider trading. Okay, any other questions? All right, don't worry, you all can think, and that's what matters. All right, here we go. So, Chapter 9, offerings by underwriters, affiliates, and dealers. So let me get the statutory text. You remember that Section 4.1 Section 5 prohibits, the sale of a security unless the registration statement is effective. Section 4.1 says, look, Section 5 doesn't apply to anyone other than three categories, right? Other than an issuer, an underwriter, or a dealer. Now, I would say, most of securities law is about issuer and underwriter liability in the context of IPOs. But there is, most of the 33 Act part of securities law, but there is a non-trivial question surrounding underwriter liability, and that's particularly relevant with the recent kind of, I don't know, you can't really call it a trend, but Spotify's direct listing. So Spotify's direct listing raises these issues. And why is that? Well, because Spotify did not use an underwriter to underwrite its shares. So the Spotify IPO involved issuing shares. There was an issuance of shares, but not with an underwriter, not through an underwriter. Remember we talked about the role of the underwriter in the book building process. So the question has come up, and it's an important question, whether traders or participants in the market, and that word participant is going to be important, whether they are actually potentially underwriters, okay? Even though Spotify doesn't have any underwriters. Might, in fact, if you buy Spotify and sell it, a day later, could you be an underwriter? And you don't want to be an underwriter, right? Because, why? Because Section 11 makes life very difficult for underwriters. Unless they did due diligence, they are strictly liable. Okay, so the definition of underwriter, I just thought we would look at it together. The term underwriter means any person who has purchased from an issuer with a view to or offers or sells for an issuer in connection with the distribution of any security, or participates, this is key, or has a direct or indirect participation in any such undertaking. Okay, so underwriter is defined in 2A11 as a fairly broad category. Now, the way that I think about underwriter liability is kind of analogous to the way that we talked about IPOs, or excuse me, what is a security? So if you remember, when we talked about what is a security, I said there's a divergence between the economic understanding of what a security is and what securities law has decided a security is. And they're not really like, there isn't a lot of like logical connection between the two. Remember we said that from an economic standpoint, a security is just a contract that pays off in some state of the world that's unknown or uncertain. So if it rains tomorrow, I'll pay you $50 is a security from an economic standpoint, but probably not as a matter of law. We went through that. Why? We don't really know why. I mean, there's this sense that securities law is supposed to be about investment. We talked about that. And what does that mean? Well, it means something like commonality of enterprises and all this stuff, right? Okay. So underwriter here kind of is defined with a similar vibe. Okay. The idea is that from an economic standpoint, if I buy and sell a security, I am transitorily, for that period of time that I'm holding it, exposed to whatever movement in the price there may be, and then I sell it to someone, and they take that risk. And we're supposed to, buy and sell at a price that reflects all the risks we've talked about: overpayment, underpayment, asymmetric information. Maybe I know something and they think that, so why would I want to sell? Remember that whole analysis. Why would I want to sell if it's a great company? So they discount the price, whatever. Okay, so that is what trading in markets is. And from an economic standpoint, a person who has purchased from an issuer with a view to the distribution of a security is like no different than a buyer who decides to buy knowing that they're going to resell. One of the problems that we've had in this area, and kind of the real central organizing question, is how to distinguish sort of common everyday risk exposures that you take on as a trader when you just go and buy Apple and then decide to sell it, or you have a view that Apple is underpriced, and so you buy it, and then you're going to turn around and sell it. How do you distinguish that from underwriting? Economically, it's very difficult, because underwriting economically is almost indistinguishable. From a legal standpoint, we think we really better answer that question, because underwriters are subject to a massive liability regime under Section 11 that induces tremendous due diligence, that imposes a lot of costs, and thus it's non-trivial, right? It's non-trivial. So we see on page 496, well, I'll just back up a second. So on page 495 of the case book, there's this discussion of the presumptive underwriter doctrine. So one kind of initial first swipe at this was to say, well, let's presume that if you buy a large block of shares, that you're purchasing that block of shares with a view toward distribution, meaning that the mere purchase of the block sort of moves you in this kind of ontological sense, right? Like literally if you bought one share and if you bought 10% of the company, like in those two cases expose you to the exact same economic risk. I mean, the magnitude is larger, potentially, maybe. Depends on if you've hedged your position or whatever. But at the end of the day, it's the same sort of fundamental risk. But if you buy 10% of the company, we're going to assume that you are an underwriter. We're going to presume that you are an underwriter. Significant percentage of the securities. So that's like, where is that coming from? It's coming from this concern that whatever test we come up with, necessarily is going to be over and under inclusive. And so let's try to come up with like a safe harbor, a bright line rule that allows block purchases, but once you cross that 10% threshold, puts the same kind of due diligence and disclosure burdens on you as would apply to an underwriter. The idea being that Spotify should not be able to get out of basically, misleading the public. Like, we shouldn't let, Spotify's never going to be off the hook, but we shouldn't let certain investors exploit their knowledge of Spotify's terrible business, some private information they have, and kind of basically buy a lot of shares knowing that they're overpriced and then go ahead and sell them to unsuspecting investors. If that happens, we kind of think they're functioning like an underwriter, right? They are giving Spotify cash at a very high price, infusing Spotify with liquidity, and then turning around and selling with we assume some kind of information. That's the key sort of theoretical assumption, right, for that story to work. And that's really like what an underwriter does. And so we think that, in that case, an investor who does that is functioning as an underwriter, even though Spotify hasn't formally hired any underwriters. So if you think about Spotify as kind of being the typical case where we're worried that there really is underwriting going on, then you can understand why the 10% rule might seem reasonable, I guess. So this is another one of those settings where the law is trying to wrap its hands around something, but it's not exactly clear what. And it's not exactly clear that there's a lot of thought behind the machinery of the 33 Act and whether that machinery really is well suited for firms like Spotify. It's a little bit of an arbitrary thing, but you should understand it. All right, so SEC v. Chinese Consolidated Benevolent Association. What happened here? I am so easy on you guys. That's what everyone says. One of my colleagues started out volunteering like this, letting people volunteer, and then switched it midstream and put people on panels and stuff. And I said, no, I can't do that. But anyone want to tell me, want to volunteer, what is this case about? Did anyone read it? Anyone? Yes. Magdalena. Yes. Yes. Yeah, so just promoting Chinese bonds. So is a bond a security? Yes. All right. That's like a multiple choice question. Yeah, that's easy. A bond is a security. Okay. There are some exempt securities like municipal bond. Anyway, but a bond is a security. Foreign government bond definitely is a security. Okay. So these folks, the members of the committee resided in New York City and urged the members of Chinese communities we read on 497 in New York, New Jersey, and Connecticut to purchase the Chinese government bonds and to accept funds from prospective purchasers for delivery to the Bank of China in New York. All right, these were unregistered securities, right? There was no registration statement filed for the bonds. So this would seem to be a violation of Section 5, right? Because these are the sale of an unregistered security. Except that the claim was, no, we are not an underwriter. After all, what does an underwriter do? An underwriter sets a price, conducts due diligence or not, but, we're just advertising the sale. We're advertising the sale. And we know formally that promoting the sale of unregistered securities, absent more, does not constitute a violation of Section 5. Right? Because Section 4.1 provides that Section 5 does not apply to anyone other than an issuer, underwriter, or dealer. So the only way you get a Section 5 violation here is to be something, to be something more than just a promoter. And since you're not the issuer, and we'll read later that the dealer category is kind of empty, and it's been basically kicked out, there's nothing there really now, you have to be sort of viewed as an underwriter in order to come under the scope of Section 5. So what is the decision here? Were they underwriters? What did the Second Circuit say? Were they underwriters? Yes. Yes. Christian, you agree? At least you had your hand up.
Yes.
Okay, reminder, okay? Participation is 30% of the grade. All right. So there's no confusion. If I don't have a check next to your name and I can't search my email and find an email from you, that's not good, okay? And if I search my email and I have 10 emails from you, because some of you every week, you're very consistent, you're not going to get 10 times the participation credit, okay? Maybe a little boost, but yeah. Quality and quantity, okay? So don't remain silent. All right, you've been forewarned. All right, so yes, they acted as an underwriter. The aim of the Securities Act, we read in 498, is to have information available for investors. Now, that's a great line, right? Because, I mean, is it? I don't know. It's really, really detailed and nuanced. Like, I mean, yeah, at a very general level, I would say that the aim of the securities law under the statute is to protect investors. The question is whether information protects them. It's sort of like, what was the case we were reading? Anyway, similar language we read earlier in the term. Was it Texas Gulf? I can't remember. One of these cases. You know, the purpose of the securities law is to have transparency, or to, well, no, because most of the time you don't have to disclose anything. All Reg D offerings are non-disclosure offerings. Like, right? There's no mandatory disclosure. So that's a little interesting. So okay, this objective will be defeated if buying orders can be solicited, which result in uninformed and improvident purchases. So I mean that's what happens all the time with every exempt security and every exempt transaction, and every transaction falling outside the scope of the securities law, like a purely intrastate deal. So there's a sense that that the court is reaching. Yeah. So I mean, think about if you push that logic. So you know, I buy a share of, you know, I don't know, Blue Apron and sell it to Mariah. So now, you know, like, the purpose of the securities law is to make sure. Well, what if then Mariah sells it to? I mean, when does mandatory disclosure stop to be a sufficient cease to be a sufficient rationale for turning each of us into underwriters? Right? At what point do we not have to conduct due diligence? It's not clear that just informed investing is enough of an answer to that question, but thus the court held. All right. One point they make is that the transaction on 499 included not only the solicitation, but the offers, the transmission, the purchase money. So there might be a stronger argument that in the facts of this case are going beyond just promoting in a very particular way, which is that you're actually handling the money, you're serving as the conduit, you're serving as like an agent. And the agency kind of story might be a little bit more compelling, right? Because if Mariah and I transact on an arm's length deal, she's not, you know, expecting me necessarily to serve as an agent of the company, and her, you know, Magdalena isn't going to think of her as sort of the one who's funneling the cash back to the firm. So there was a sense in this case that it was maybe the role that this committee was playing on behalf of the Chinese government, although the facts were pretty clear that the Chinese government didn't seem to know what was going on. There's this reference. Let's see if I can find this. Whether the Chinese government, so this is on 498, whether the Chinese government as issuer authorized the solicitation or merely availed itself of the gratuitous and even unknown acts on the parts of the defendant whereby written offers to buy and funds collected does not affect the meaning of the statutory provision. In other words, the court seems not sure that the Chinese government was involved, because if it were, it would be a stronger basis, right? It would seem more like a typical underwriting transaction. So what does that mean for a case like Spotify? Just applying this case, that, you know, if you're trying to make a market in Spotify stock by, you know, essentially buying less than 10%, but some reasonable quantity, and taking the money and more or less effectively funneling it back to Spotify, you might be an underwriter. Right? And that's a big deal. Does everyone see that? That's a simple application of this case. Promoters, probably are going to be viewed as underwriters, especially if they're doing something more than just advertising or soliciting investment, but actually receiving money. Okay, yes, Mariah. That's right. So the 10% is history, but remember that if you're in Spotify, what you're really worried about, or not Spotify isn't worried, right? But if you are a buyer of Spotify, what you're worried about is, if I'm out there and I'm essentially taking the risk that an underwriter takes, I am doing diligence into Spotify. I am researching Spotify's prospects, and I am buying, and it could be a small fraction. Right? At the end of the day, you're kind of doing what an underwriter does, and that's what's bothering the court here. So it's not, the bright line rule was the first attempt. Remember back when we were talking about what is a security, we said, there's this idea that, consumption, like the case involving the real estate interest, right? Well, consumption is not a security, but why? Well, how much consumption is needed to not make it a security? So the bright line rules prove very problematic when you're trying to grapple with dividing the legal from economic treatment, right? So the legal treatment here is that something is going to turn you in to the underwriter. And the size of the stake doesn't make sense, although the SEC's guidance points to that as making you a presumptive underwriter. It doesn't make sense, and we see in the Chinese committee case that it's not dispositive. And in fact, the point that's really bothering the court is that investors on the other end are using the services of this intermediary. So it's a way to think about this as kind of like, what role do intermediaries play in raising capital? And the strongest argument in favor of characterizing a trader as an intermediary is that they're actually doing what an intermediary does. So if I am creating this liquid market for Spotify, that's far more important based on the law that we have, but also there's a logic to that. It's far more important than the size of the block that I happen to own. So the evolution in this respect reflects the problem of trying to find a not too over or under inclusive line, but at the end of the day, you still have to wonder why it is that we have this particular sort of regulation of intermediaries or those performing their function. Yes?
Well, before we go on Spotify,
Yeah.
I have a question about the case.
Yeah.
I'm not sure if the court really distinguishes the fact that this Chinese committee is dealing with government bonds. And I'm not exactly sure if the same kind of ideas or rationale for underwriter or the
Yeah, good.
applies to government bond the same way it would to corporate issue stock.
Great, right. So on 499, the courts refer specifically to Section 2A2 and Section 7 saying, look, right, securities issued by a foreign government, including government bonds, are securities. But your point, I think, is why? I mean, it's not clear, or maybe fine, will regulate the issuing of foreign government bonds under these concerns, but underwriter liability in this setting seems a very tenuous proposition. Actually, foreign government bonds is a fun case because if you think political risk matters to private companies, political risk is probably the only thing that matters, right? I mean, grossly oversimplifying. And so, there is a real question of what it means to think about disclosure. Now, just so this is clear to everyone, okay? The government of China is not a public company, okay? So you need to keep these distinctions, okay? The government bonds are securities. By the definition of a security, a bond is a security, and particularly a foreign government bond. That means that the 33 Act regulates the offer and sale of those securities. It does not mean that the kinds of overpayment and underpayment risks that we were discussing when we were talking about private companies translate one-to-one. Now they could, or they could be more on point if you recharacterized risk as not sort of something about the firm that isn't known, that the entrepreneur knows, but actually like the political stability of the country, or even its intent to pay back its debtors. For those who are familiar with the Argentina bond litigation. So the definition of what is a security and who should be allowed and what investor protection means in this setting, those are difficult questions. They're fun questions, right? They're fun questions because they require you to think carefully about mispricing. The role of the underwriter is a related fun question because individuals like this committee who are willing to promote or to collect money on behalf of the foreign government or just to advertise, are they themselves functioning in the same way that the Spotify underwriter would? And that's your point. And I think you're right. It's not clear. It's not clear because whatever political risks that are known to the issuer, the government of China, are not necessarily known at all to the underwriters. So they may not, the story whereby they buy, this is a great point, the story whereby they buy knowing that this is overpriced in order that they can essentially, rip off the ultimate purchaser from them, that story seems a lot harder to sustain in this setting. I agree with you. So I think that's a very good insight, and that exactly, and that's how you want to be thinking. Yeah, very, very good. Very good. Other questions on this? So, think about ICOs, okay? You could, possibly get a crypto question on the exam, and if we did that, I wouldn't expect you to know, like, technical stuff. I try to spell it out. But think about that, right? Think about, if you tell your friend about about an ICO that they should invest in. If I stand up here and tell you to put your money in, I don't know, some of these ICOs, like I don't even know what they do, but okay, some random ICO, does that, turn me into an underwriter? Probably, right? Probably. There's a really strong case that I'd be liable under Section 11, strictly liable for misstatements or omission, and strictly liable under Section 12 for a right of rescission. Bad news, right? Bad news. Bad news if you are getting out there and talking about how great Spotify is. Bear in mind one last thought on that promotion question, sort of First Amendment considerations. Anyway, okay, Guild Films. We're going to do this one quickly. The facts are more convoluted than this is a very complicated case. There's like a parent company, then 2 levels down. There's sister companies that have made loans to each other, and securities weren't delivered, and it's a mess. But bottom line, you got a bank, Santa Monica Bank, that has lent money effectively, and they are holding unregistered securities as collateral. That's really the key point. These unregistered securities are not very useful because they are pieces of paper, and in the event of default, the bank is looking for money, not pieces of paper. And so the question really that arises from this case is, can a bank be considered liable as an underwriter? Can we loop in the bank when they are selling the security, even though they didn't buy the security, but they're selling it pursuant to the exercise of their rights in a lending agreement? So does the fact that you've pledged securities as collateral, as a security for a loan, does that sort of immunize the bank from being viewed as an underwriter? So think about it from the bank's perspective, yeah, we lent you money, we got securities pledged as collateral, now you're not going to pay, or that's what it looks like, there's some concern, and we're exercising our rights under the credit agreement to call the loan, meaning we're going to take the securities and we want cash. Well, what can we do with them? They're pieces of paper. They're not useful to us. We need cash. So what do? Well, the bank calls up a broker and says, can you please sell? The banks attempted, we read on page 502, to sell the securities through brokers on the American Stock Exchange. And what the court is not happy with is the point that, look, at the end of the day, the buyers, the ultimate buyers, are still buying securities from you that may be worth nothing, or maybe worth a lot less than the price you're paying for them, that they're paying. So the fact that you didn't purchase these securities from the issuer with a view to distribute doesn't get you off the hook if you're effectively distributing them when you exercise your rights under the loan agreement, right? When you exercise your rights to seize the collateral and to liquidate the stock. So the court points out on 503, when the 50,000 shares of Guild Film stock were received on February 12th, the banks knew that they had been given unregistered stock and that the issuer had specifically forbidden that the stock be sold, whatever. In other words, the court's sort of point here is, look, we're not letting you off the hook because you knew going in when you accepted unregistered securities as collateral for the loan that you wouldn't be able to sell them, but by, there's very limited means to sell unregistered securities, like it has to be pursuant to an exemption, or you would have to file a registration statement. You knew that going in. So don't pretend to be so, miserable. Don't pretend to be the victim here, because those were your expectations going into the deal. Now, this is another example, okay, of what expectations are is often an ex post normative decision. At the end of the day, the court could have said, no, we want to encourage, a lending market. We want to encourage credit markets. We want the cost of credit to be low. Okay, by basically saying that the bank could not sell these unregistered securities, the court was saying this collateral is no good. That means that the cost of credit, all else equal, should be a little bit higher because on the margin there's some loan out there that's going to need to use securities as collateral, whatever, they're cash poor, and so that is going to be a little bit harder, which means that credit is going to be a little bit more expensive. So by construing investor expectations in this way, the bank's expectations, I should say, in this way, by saying, look, you knew you couldn't sell it, and we're going to read the statute so firmly. At the end of the day, what you're doing is just saying, no, unregistered securities cannot be used as collateral, which has consequences. So notice again here, we did this one quickly, and it's not that important, but notice that at the end of the day, the underwriter's standard is very broad, but when it really comes down to it, you're going to kind of say, what did investors expect? What did the presumptive underwriter expect? And those expectations tend to be normative judgments. So what are investors expecting when they buy and sell Spotify? You can think of that question as being deeply tied to what the putative seller is, in fact, of Spotify stock. What the role they're playing in the market cannot be severed from what their counterparties are expecting or viewing that transaction as effectuating. So if you can imagine facts where people say, look, everyone understood that Goldman Sachs was buying Spotify shares, and everyone understood that by buying those shares and then reselling them, they were serving as a de facto underwriter. The investors on the other side expected that. They understood that. That is just, of course, as you now should be sort of instinctively reacting, that's an ex post characterization of the transaction. You're sort of saying, yeah, we want Goldman Sachs to act like an underwriter in the Spotify deal. So the way to think about this standard is that it's often going to turn on expectations. It's often going to turn on how strictly you read the statute. And you could often just as easily come to the conclusion that you're not purchasing with a view for distribution, but rather, or participating, in distribution, but rather you are just buying and selling with a truly economic motive. This ambiguity, around this question, is going to motivate, we'll talk about on Thursday, Rule 144 and the desire to set some bright line rules so that we're not constantly relying on sort of ex post characterizations of investors' true intent in purchasing a security. All right, that's enough for today. Probably see you on Thursday, unless the storm weakens, in which case I'll see you tomorrow. I'll post an email update with that announcement about class. Yeah. Yes. If we have class tomorrow and I'm here, I will confirm office hours. It's definitely in the afternoon. Yeah. Oh, yes. Thank you. 3 L's. Thursday, 12 o'clock, you have an exam. So we'll end 11:45. So does that give you enough time? Do you need more time? 11? All right, I'll videotape the class. I'll end a little early for those who want to stay. We'll make the video available for Thursday if you really need to leave earlier. Yeah, no problem.
I was just going to email him.
You got your bag? Is that your bag? And then bring mine too. Because I was afraid I was going to get rained on it. Yeah.
Exactly.
Yeah, it's like it's not going to be bad until like tomorrow or maybe.
It would be awesome.
They would like make they would
And like,
like that would be one of the worst. Like they say like 11 to 6 or whatever. Yeah.
yeah, it seems like very common. It seems like we might come another day like tomorrow, like we had before.
I don't think it's going to be as bad as last.
Right. Because
It seems like it's going to be a lot more like extreme. It's like for people like South Jersey, it's so bad. But
I mean, at any moment in time, you can go conduct a survey and say, do you think investment that, what is the chance you're facing the entry? Who doesn't have it? And you might say, at this moment, I can give you data that 65%, they think there's 65% chance that facing day traders will inform it. But it's not, it's not an empirical test.
you got lucky because of daylight savings. They do it like 2 weeks after. On the way down,
Basically, right. Yeah. Basically, the difference was like 6 hours the first day I was there, and then 6 hours. But, yeah, I went to that